The Australian legal market has become very competitive and more pressure is put on law firms to become more advanced and quicker, not only on how to serve their clients but also on how they bring more revenues to the firm and transform their business. As such, there has been growing appetite for litigation funding in Australia. According to 2018 Litigation Finance Survey, from 495 lawyers and corporates in Australia, the UK and the US, found that 83% of Australian respondents anticipated litigation funding to be progressively significant in the business of law. Moreover, among lawyers whose organizations have not utilized litigation funding, 72% of Australians conveyed being likely or very likely to make use of it in the next 2 years. In comparison to 3 or 5 years ago, class actions have significantly increased, said Michael Mills, a founding partner of the U.S. firm Quinn Emanuel Urquhart & Sullivan's Australian office. There are many more actions around. In the first half of 2018, total of 29 class actions were filed, and the second half of the year 35 cases were filed, total of 64 for the year. Early in 2019, the Australian Law Reform Commission (ALRC) is anticipated to release the results of its investigation into the litigation funding industry in Australia, with a specific emphasis on the role financiers will produce in the class action area. If the recommendations are applied, this could potentially change Australian legal structure. Amongst the planned recommendations was the licensing of litigation and solicitors acting in class action proceedings be allowed to enter into contingency fee agreements.